Is liberty dying where you live? Escape to Keene at freekeene.com.
I know she appreciated that, but the message didn't really get to everyone else who had their phones confiscated. And so for that hearing, people were unable to appropriately take notes or tweet or do what they felt was important there. And again, the officers, when they were confiscating these phones, I was pretty surprised by it, considering it was a huge change from the last year and a half. And I inquired with them as to, was there an order filed by you in regards to this hearing? And they said they were following the order as posted, and I checked with the clerks, and they said that you hadn't filed an order, so they said that they were enforcing the 2011-50 order, which, again, doesn't authorize them to confiscate a cell phone. It only prohibits the recording of whatever it is that's going on in the lobby. So I question whether or not these guys have even read the order in question, or if they totally understand what that order says. I do object to the order, and I don't know if there's any way to put that in officially, my objection to it. I think that the idea of banning media devices from a public place is abhorrent to the idea of transparency and government accountability. Obviously, you can't override the order of Judge Nato, at least I don't think you can. If you could, I sure would like you to write an order that allows anyone to bring any media device in, so long as they're not being disruptive of the court proceedings.
Let me say, I think you can safely assume that in terms of how I intend to proceed, it's to apply the order of Judge Neto and the Superior Court rule that's in place. I do think this question of live tweeting is an interesting question, and one on which I'm going to do some further analysis going forward, because I think it raises some interesting issues. And I don't know if you've found any further authority other than the constitutional arguments that you've made to support the notion that live tweeting should be permitted.
Well, I mean, the Supreme Court itself live streams their hearings, from my understanding. So I would argue that more openness is the answer, not less. And these folks here are attempting to put the kibosh on the independent media from coming in here. And I would guess, and if we were able to actually ask them questions, I would guess the reason they picked on Kyle Jarvis from the Keene Sentinel on the day of the Rich Paul sentencing was because he was guilty of sitting too close to me and some of my friends, so they perceived him as being part of the activist group that was there that day and threatened him, which was quite the surprise to him. I don't know if you heard, but as I understand it, the Keene Sentinel has submitted some sort of a letter to the clerk of this court expressing their concern over that particular issue. Kyle was very shocked by what happened, because he'd never been treated that way by court security before. And when he questioned him, because all he had was his laptop out, Mr. Searles came out and immediately yelled at me as I was tweeting or Facebooking, doing an update on my phone. He yelled at me and accused me of recording and told me he was going to kick me out or take the device. I don't remember what the exact threat was, but that I wasn't supposed to do that, from 15 feet away. So how it was that he determined that I was using my phone to do a recording of some sort, I'm still not sure. I don't know if Mr. Searles understands that these devices are capable of multiple things.
I think that's one of the issues is that the devices are capable of so many different things that they can be used to record, to tweet, to video, depending on what the device is. So they have a lot greater capability than probably even just a few years ago in terms of what they can do.
It would seem that if Mr. Searles had evidence that someone was recording, it would be more appropriate for him to ask that to not happen. But in this case, all he saw was me with a phone and decided to exert his control in that case. Then he accused Kyle of actually setting up to record. So he believed that by opening the laptop that was leading to Kyle recording something, when in fact he was simply typing up his notes that he had taken during the trial. He proceeded to inquire further then Mr. Tebow joined Mr. Searles in his threats. And Kyle proceeded to inquire as to whether or not he was able to simply take written notes of an interview. Could he interview, say, John Webb with written notes? And it was made clear to him that he would need to leave the courthouse if he wanted to engage in any interviewing whatsoever, which is a total misinterpretation of Judge Nato's order that does not prohibit any kind of note-taking or written interviews. It only prohibits recording in the courthouse. But again, that didn't stop them from throwing him, Kyle Jarvis, out into the rain.
Let me ask you, so your concern, setting aside your general objection to really any restrictions on media in the courtroom, I take it that your concern is about how the rules are being applied, in a fair manner.
It's pretty clear from the Rich Paul hearing that they were being applied, that they were arbitrarily being made up on the day in question because they were confiscating cell phones, which they hadn't done in over a year, and they were being applied in a discriminatory manner only against the people attending that one hearing. I stood there and watched as other people who were not attending the hearing, but bailiffs were asking people what hearing they were attending, and then changing their security procedures based on that. Can I get some water?
Absolutely.
I appreciate that.
Let me ask you, Mr. Freeman, in terms of going forward, and again, I know there are some issues about exactly the status of the case, and the parties are going to file some additional memoranda of law if they choose to do so. But in the event the case, and again, I haven't seen any further filings beyond the affidavits that we've talked about and some discovery issues. But if in the event that I don't dismiss the case and we go forward and have further proceedings in this case, do you have a proposal for how, in your view, the media rule should be applied?
You mean specifically?
I mean, I take it you're beyond your objection generally to. I mean, I take it you would say any and all media should be permitted without limitation in the courtroom.
Well, no. I think that there's reasonable restrictions. Obviously, certain court rules regarding media in the courtroom were put into place to prevent, say, the jury from being distracted by someone running back and forth with a camera or whatever. So.
And one of the things that, one of the themes that you see in the rules and some of the procedures is really to not make it be disruptive.
Right.
To permit open access while at the same time being conscious that the parties need to have a fair opportunity to present their case, and the jury needs to be able to follow what's happening in the courtroom without disruption. That's why there are some limits on pool coverage and other things in terms of the numbers of photographers. You can't have
There's only so much
20 people. Yeah, then as you know, this is a very small courtroom. So there are some of the rules are set up to make sure that there's not a disruption to the important things that are taking place in the court.
No, I would never advocate for any disruption. That doesn't make sense. It would. I don't have any objection to.
Not saying everybody should be allowed to have a video camera in the courtroom.
No, I don't think it's unreasonable to restrict access to a certain number, and I think that allowing more than one is good because pool access can be a real hassle, especially when you're dealing with professional media equipment and consumer level media equipment, like kinds of consumer level kind of camera. The day when Rich Paul's hearing was happening, I was glad that you allowed WMUR to set up across from me, so we had two cameras in the courtroom, and that way I didn't have to deal with whatever proprietary issue they might have, or they would have to deal with my lesser quality footage or whatever. So that made sense to me. My real objection is in the way media is restricted outside of the courtroom. I'm bothered that it's a public place. I mean, we're not talking about going back in the clerk's office. We're talking about a place that anyone from the public, once they get through the security checkpoint, can enter, go into, ask questions of the people that work here. The problem is I can't ask questions on the record of anybody that works in this building, and I'll give you an example of what happened in December of 2011. I was given a trespass order by the sheriff at the time, Sheriff Dick Foote. Myself and several activists were given that same no trespass order, which banned me from the entire court property. And the reason was allegedly for persistent harassment. Now, I'll have you know that that trespass order was overturned as unconstitutional as applied by Judge Burke in district court. So it was nonsense, but it did effectively ban me from coming on this court property for a period of a year before I was able to get to the hearing to where it could be overturned as unconstitutional. But the persistent harassment that I was accused of was standing in the parking lot with a video camera asking questions of the court workers, the employees, as they came to work and as they left work. Why did I do that? Because I couldn't go into the courthouse during business hours or at any time. I couldn't go on the property. I could not go in, I hadn't been banned yet, but I couldn't go in with the camera to ask those same questions of these people while they were on duty. So the only way I had left was to wait for them to get off work and then ask them those questions.
So let me ask you, in terms of outside of the courtroom, I think your concern is about the ability to be able to ask people questions in an appropriate. Obviously, we don't want people right outside the courtroom door while proceedings are going on, so it's a disruptive thing.
Sure, we're not talking about making a bunch of noise, but yeah, but holding the government accountable. Yes, questions to hold them accountable, and also just recording their behavior. If the bailiffs are treating people rudely at the checkpoint, there's no evidence of that. I can show you video where Carlos Miller, who is an advocate and an independent journalist from photographyisnotacrime.com, he came up to visit us here in Keene back in early 2012, entered this courthouse with a video camera, and was immediately threatened by, I believe, this gentleman sitting here on the left. They called sheriffs on him, and the sheriffs threatened to arrest Carlos if he did not leave the building. So this is not an uncommon thing that happens. Carlos has had it happen to him a lot. But just because it's not uncommon doesn't mean that it's okay. If government employees are behaving badly, we should be able to show that. We should be able to show the public how their so-called servants are operating. And in this courthouse and other courthouses around New Hampshire, that's just not possible due to this order by Judge Nadeau.
Okay, now you're back. It sounds like what you're talking about is something that would have been concluded under Judge Nadeau's order. The court just going into a building without having given any advance notice and just start recording.
And nor should anyone have to give advance notice if they're going to walk into a government facility and start recording. If I walk into Keene Police Department, they can't tell me to leave. I have a video camera. I have a right to be in that place as a public place, and I have the right to record my interactions with government officials. In fact, I just had a case in Palmer, Massachusetts, where I was arrested for walking into town hall with a video camera. They ended up settling that case and giving me a check for $5,000 because it was wrong for them to arrest me for that. I don't have to call town hall and give them advance notice, and I'm going to come in and try to hold them accountable. So again, for whatever it's worth, I do object to the rules about cameras being in the lobby, but ultimately those cameras not being allowed means that these guys can get away with any amount of threats and rudeness that they want to, and you never find out about it. And so I'm glad that you've taken the time to listen to that.
Not a problem, and I just want to know if the city takes any position on this. I know there's a general objection. It wasn't any more specific than just a general objection. But if you want to say anything further on the issue.
Thank you, Your Honor. I'm not going to take up too much time because we did file that general objection. And as stated in the general objection, the city had no direct interest in this matter before the court today. In addition, the city wasn't present at the June 7, 2013 sentencing hearing at which the defendant alleges that the Administrative Order 2011-50 was misapplied or misinterpreted. However, notwithstanding those disclaimers, I do want to state for the record that the city's experience has always been that they're able to do a very good job under often difficult circumstances, ensuring that the court, including the lobby and the other public areas, which I think are important areas of the court, remain a safe, dignified forum that's also free from unnecessary disruption. And at least from the city's perspective, having multiple cameras and interviews going on and question and answer sessions could be a disruptive scenario. To the extent that the defendant challenges the bailiff's ability to perform those important functions, the city objects to this request. I also note for the record that this last part of the argument relative to the public areas of buildings being completely open to filming versus other areas, I think the city would object to filming in certain areas of City Hall, certain areas of the police station, for example. That there are public forums within those buildings.
Thankfully, I don't need to address today,
but just for the
rules
record,
apply
for the record,
in all other city buildings. So.
Yeah. But just for the record, I do want to point out that distinction that we do not allow filming in all of City Hall and all of the police stations.
Thank you. I'll take this motion under advisement. Very briefly, because I do need to move to the next.
There was one other episode or incident that this statement reminded me of, and that was right before the hearing for the Robin Hooding, the first hearing that we had recently. Mr. Tebow came out and asked people sitting in the audience, he wanted 7 volunteers to get up and leave the courtroom in order so that the city people could come in and sit in the seats. Now, this was at the request of the mayor, and I recorded that. That happened to be caught on the recording, which was rolling at that time. So there's video evidence of this. The mayor asked Mr. Tebow to clear those seats. The people did not get up from their seats, and you ultimately did rule that the individuals in question who had wanted those seats would have to be sequestered per my request in that case. But it was just an example of how the court security treats people that work for the government as a separate class of individuals with special privileges versus the average person who comes in here is not treated as well as they might treat this guy and the people that he works with.
One of the issues, as you know, is unlike a lot of courtrooms in the state, this courtroom has very limited space for members of the public, and one of the things that will benefit from the new courthouse, assuming the design works out the way I've seen it, is that there will be greater access for the public, so there are more seats. I know there have been some hearings that you've attended where we haven't been able to accommodate people because we don't have all the seats that are necessary.
I'm looking forward to that expansion.
Thank you. I'll take the motion.
Thanks, Sam. Just to clarify, the motions are due basically by Friday, right? You had said 20 days, but I think that time's out for
While we're all here, I'll go back and take a look. It would be, but the way I'll interpret that is as long as something's in by Monday of next week, that's fine. Because the 20th day is actually, I think it is Monday.
Yeah.
So
okay,
my math needed to be corrected. It is Monday. So anything filed by Monday. Thank you.
Thanks for listening.
Have a good afternoon. Bye.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.